how would the data collection lifecycle look in practice? First, a company must collect data from Russian citizens and record it in a Russian database. It cannot initially record data to a database located elsewhere, but it can use an application or website located somewhere else. It's only about a database. Second, if a person, like a website user or an individual, wants to update or change his personal data in his account, then these data updates and changes must be initially implemented in Russia as well. Formally, the law also requires to perform some additional operations like systematization of personal data, retrieval of personal data from using the Russian database, but these particular requirements are not currently enforced in practice. What the authorities do strictly require is that initial recording and subsequent data updates are carried out in Russia only. After that, company may export data from Russia and use it in the global IT solution. So to sum up, the law requires that most operations with personal data must be initially carried out using a Russian database, but it doesn't prohibit company to, after this, to use a global IT solution. Why is this important, and what are the possible risks for companies? Let us try two scenarios. One, if we have a company located in Russia, and the other, if we have a company that doesn't have any local presence in Russia. It only has a website and it doesn't have any offices, branches, or anything located in Russia. So the first thing that will happen if Russian authorities identify a potential violation is that they will issue an order to bring the company's data processing activities into compliance with Russian personal data laws. Typically, they will provide something from 1 to 6 months to cure the violation in a way that is convenient for the company. And the company will itself determine how it will remedy the violation. It may implement some local system, or it may just decide to remove personal data. In some cases, when it has limited time, it may actually need to remove personal data because other compliance options will not be possible to implement in this period. Russian authorities also have the right to demand that a company immediately suspends processing of personal data, but this is not very common in practice. There is also a high risk of administrative fines, and according to a recently enacted law, the penalties for lack of data localization may vary from $15,000 to $280 per violation. And there is some dispute how many violations can be established as a result of one investigation. But we've seen some recent cases where the number of violations was actually multiplied by the number of individuals who complained. We also can note that if there are several penalties that are imposed on the company and its responsible executives, then these executives may face difficulties with entering Russian Federation, because if they have several administrative fines, they might be denied visa or entrance to Russian Federation. There is also a risk if we speak about just websites and a company that doesn't have local presence in Russia. There is a risk that this website may be blocked, but it's not very high. Why I would say that? Because first, only those websites that are found to target Russian users can be considered subject to Russian personal data laws. And if they are subject, then they can be blocked. If they are some global websites that do not specifically relate to Russian Federation and activities in Russia, then they will not be required to comply with Russian laws. Second, this is a temporary measure, and if a company cues a violation, then the website will be permanently unblocked. And third, the issue is decided by a court, and the proceedings can take several months before the blocking is actually implemented. So the company will have an opportunity to bring its systems into compliance with Russian rules in order to avoid potential blocking. Well, there is also a risk that these proceedings, these compliance orders or website blocking action may trigger bad publicity for the company. And based on what we've recently seen, Roskomnadzor, the Russian Data Protection Authority's officials, tend to make some official press releases or public press comments where they will tell that a particular company doesn't follow Russian personal data laws. And sometimes that gets very big coverage in Russian and global mass media, which can be very detrimental for a public company. So the interesting question is, well, you have all those issues and risks. What our company should do to bring itself into compliance with their localization requirements? What I will describe now is not like the only available options. We've seen different setups and different solutions, but I would like to highlight the ones that are most common in practice for certain activities and maybe most easier to implement in some cases. So the first is the situation like payroll data or HR data. When a company has a subsidiary of a multinational company or a local agent have some local IT system which is used for a very similar purpose and contains the very same personal data of individuals. So the localization compliance with these rules is based on the idea that you first enter the data into the existing local solution, and then the company copies these data to the global IT solution. The legal issue here that should be taken into account, that the company should not allow its users themselves to directly record data into a foreign IT solution. So for instance, we have one C payroll system in Russia, and we have some global HR management system outside Russia. So if you say that your users should provide their information to local HR officer who will enter it into one C and then copy the data from one C to the global HR management solution, that's fine. But if you allow users to directly interfere with the global solution, then the problem will be that the data will be immediately entered into global solution without first being recorded in Russia, or the sequence, the procedure will be found to be different, not as required by law, Russia first, foreign instance second. And the company, the Russian company and the European or US or other company can both be found to violate the data localization requirements. Just avoid this, and if you implement it this way, make sure that it's implemented just as depicted on this chart. Second option, sometimes it's easier for a company to copy its existing solution and just create a local instance of the very same IT solution from which the data will be exported to the global database. Sometimes that's relevant for websites, for some financial data management system, email servers, and things like that, where difference in technology can have very huge impact. In these cases, the procedure would be the same, but the difference is that the Russian instance and the global instance will be just based on the very same software solution. While in this case, the suggestion was to use existing local IT system, which is based on a local software. The third option is not very common, but is sometimes used in practice. If you have a, say, global website which is used to collect personal data of Russian citizens on a wide scale, you can create a solution that will, when it encounters a Russian individual, it will initially record his data to some interim or buffering database located in Russia, from which the data will be automatically copied to the main global database. There are different ways how that can be technically implemented. There could be special gateways for Russia where Russian users would be directed, or the system may just determine that the user came from a Russian IP address. But in any scenario, there will be some local database, global application, and the data will be stored in Russia in a systematized electronic form, which would comply with the law. It's not common, as I said, but we've seen companies implement this in relation to some recruitment websites, landing pages, and sometimes for some online stores as well. The easy option to consider for most companies is whether you can avoid collecting personal data. If you can remove all personal data from a web form and only collect data that is non-personal, for instance, relates to the company or to some processes or inanimate objects, then all this data will not be subject to localization requirements, and the company will be able to use the global IT solution straight away. It doesn't always work, but it's the cheapest option when it's convenient for the business. And one other solution how to achieve cheap compliance is to make sure that the global website or service do not fall under Russian personal data laws. As I previously said, in order to be required to comply with the localization requirements, the company must be subject to Russian personal data laws. According to the existing interpretation of the law by Russian authorities and courts, the company is only subject to Russian personal data laws if it targets Russian users online, when we speak about online environment. And that would not be the case for a global corporate website, provided that it's not translated into Russian language, doesn't display prices in Russian rubles, doesn't deliver electronic or physical products to Russia, but still, so it doesn't have any direct link to Russian users, but can be used by Russian users on in the same fashion as users from any other countries will do this. For instance, when you have a careers website, jobs website, and would like to collect applications for a job in UK or in France or somewhere else outside Russia, and well, you accept applications from Russia, but you do not specifically ask Russian users to apply. You ask any users from any countries of the world to apply, and because of that, you do not target specifically Russian users and are not subject to the localization requirements. So, and one last option to consider, which is not something that companies love to do, but they sometimes do, is that due to localization requirements, they simply isolate Russian IT solutions from the global IT systems. Of course, we know the general trend to use global clouds, global IT solutions to save on costs. But because compliance with the localization solution with the localization requirement can be very costly, it's sometimes easier and cheaper just to have something different and isolated for Russia than to build a compliant way to integrate with the global IT system. So these are the most common ways to comply with the localization rules. And I now pass the word to my colleagues to continue on other issues. Thank you.